What rule defines the breach risk assessment, David?
The breach notification rule.
Boom. See, I'm smarter than the average bear.
I so smart.
Help me with hip-hop. Let's get it right. Protect your patience. Day and night. Donna and David, the experts on your side. Help me with hip-hop. Let's get it right.
All right, today we're going to be talking about the 15 million record covered up. Dum, dum, dum.
That's a lot of blankets.
Yeah, not 15 million covers, but cover up of 15 million records. So yeah, we'll get into it in a little bit, but yeah, somebody tried to cover it up and it came to light, and we'll talk about that.
Yes.
So before we do though, CISA urges endpoint management and hardening after the cyber attack. Let's talk about that first.
Well, it was like we just recorded the episode for last week about Stryker, the attack, and what we thought that should make everybody pay attention. And like 2 days later, there was a alert from CISA saying everybody needs to pay attention and that you should do some hardening. So just wanted to make sure I shared that they agreed with us. That's really... be alert, use principles of least privilege on the admin roles, enforce phishing resistant MFA and privilege access hygiene, and configure access policies to require multi-admin approval in Microsoft Intune, since that's what the Stryker thing used. But I don't know that they've still come out with anything, but I thought it was interesting that 2 days after we recorded, I saw they agree. So anyway, there's a link to their alert there in the notes. And then we get our real fun of the day, though, new settlement.
Yeah. Yeah, we have a new settlement that came out, and we just haven't covered it yet. But it does beg the question that if a breach happens at a business associate and they don't tell anybody, did it really happen?
Apparently, some people think it does not.
If we just don't tell anybody, it'll go away. So apparently not. And this settlement marks OCR's 12th enforcement, the enforcement actions of the OCR's risk analysis initiative. But as we see in every single one of these enforcement actions, the risk analysis is a problem. Has been since, I don't know.
I think we've always said it's the number one thing.
It's been around since before HIPAA has been around. It's always been a problem. So, but this one, there's some interesting facts, on this one. We'll go through those. Not only was it, a cover up, what we don't know, I think intrigues me more than what we do know. Like,
I know. I hate it that we don't get the details.
I know. It's like,
if somebody knows them, will you call us or send us an anonymous message? Say we have them. And if we just know and we can't share it, I'm fine with that. But I need to know, because then I can deal with how I could prevent that.
You can even use a voice changer when you tell us.
Oh, yeah. Sound like Minnie Mouse or Donald Duck or whatever.
Oh, yeah. But so this one, we'll get into it here now, is MMG Fusion LLC, and they're a HIPAA business associate.
Yes.
Company out of Maryland, software company.
Mm-hmm.
You've worked for software companies before.
Yeah.
Yeah.
Yeah. Done that work, and always worried about security, and that was long before we lived in the world we live in today.
Yeah. Well, security is not that important these days in a lot of ways, and I'm not saying anything about this particular company, but I've mentioned before, I was watching a podcast one day, or the vodcast part of it, and they were talking about building apps with AI. And the lady literally said, security is important, but you need to ship first. Like, we can worry about the security part later. You need to make sure you have a viable product that people want to pay for, and then you can worry about security. And I'm like, no.
You got to worry about some of it. And, that's why you can do beta. Make sure somebody wants to pay for it, Anyway, and I get it. There's so much about getting something out, getting it on the market, getting an enhancement or a new version out. I get it. I used to have to go through it, and I hated that it took us a long time the way we used to do things back in the olden times. And they develop differently today. They use different not frameworks, is, agile approach versus the design and quality controls and all that. Who needs that?
Well, not just that, but as a society, we've changed how we look at software updates. Used to, a software update happened like once a year. Like when you bought the next version, that's where your update. Mm-hmm. Now, like I was looking at a post the other day and somebody commented, there's not been any updates to this software in 3 weeks. I think they've abandoned it. And I'm like,
3 weeks?
Yeah, I'm like, come on, folks. You really want... it does. Like there are certain things that literally ship with update. And I think AI is certainly one of the issues here too. Like they're seeing updates happening sometimes multiple times a week, but at least weekly. And so you take that and you plug that into a piece of software where they're coming out with an update quarterly and people are like, what's going on? Why is there only this quarterly update?
But it is a mindset concern. And, I would prefer a balance between I need it right now or do I need it right? Somewhere in there, in between the two. I need it mostly right now is what I need. Mm-hmm. But anyway, this company, apparently they are marketing and patient communication platform for dental practices. And those are the ones that always tell me, we've got HIPAA covered. I have never met one of those folks that didn't tell me that. With a great deal of confidence, the minute that they knew I did HIPAA, and they're my favorite ones to tell, no, I get to decide that for my clients, not you. So we've got a business associate that had 15 million patient records exposed, and they told no one.
I think part of me is impressed they even knew.
This is the perfect example of why so many things that we talk about that you have to worry about your vendors. Mm-hmm. Probably this vendor answered some sort of vetting at some point, one would think, as widespread as it is. Now it is dental, so,
yeah.
But, it's a vendor in your supply chain. Number one, this is a big thing. They have so much data. Number two, so when it happens, it's big.
Yep.
Number three, so often business associates think they don't have to worry about breach notification requirements.
Mm-hmm.
I am sure that they, in their business associate agreement, even gave themselves the full 60 days.
Of course.
But still didn't do it. So let's talk about what really happened. Well,
okay.
The part that's driving us crazy. Okay, so there was December 2020 cyber attack where they know there was unauthorized access. They know data was exposed. But here's the tricky part, and this is not clear. When did someone learn that PHI that was stolen got posted on the dark web? I didn't see that in anything I read. Did you?
No, I didn't. So I don't know if, somebody reached out to them and said, hey, you need to pay us this fee so we don't release it. And they were like, no, we don't know anything about that. Or I don't know. There's no information about that at all. So
we've seen enough of those panic meetings where somebody decides we're not going to tell anybody.
Now, I have seen, not anything to do with this case, but I have seen where people have called doctors' offices or dental offices and said, hey, I found my information floating around.
Yeah.
I Googled myself and I see things I shouldn't see about my medical history.
Yeah. That used to happen frequently. I don't know why it does. I guess because now it's out on the dark web and it's not just easily identified. But the reason that we know about this is because somebody called OCR and filed a complaint that they saw the data in 2023. 2023. Wow. And we don't know. We don't know if it's security people. We don't know if it's, a patient and hackers.
Who knows?
Yeah, it could have been them,
It could have been.
And I don't know.
Yeah, my immediate thought is there was an employee somehow that had knowledge and they just decided for whatever reason it was time to tell somebody. Now, I don't know that. Don't know that at all. But I kind of think if it was the bad guys, I think it would have been closer to the 2020 timeline.
Yeah, unless they didn't realize they could do it. But it's either got to be, I believe, either the internal person who knew about it and for whatever reason, whether it was guilt, spite, or just I need to do the right thing, who knows? That,
for all we know, it could have been their MSP.
it's some internal force, or a security researcher found it, which often security researchers will find it. And that is probably what happened. But this just goes to show you where we tell you, if you think, oh, I'm not going to tell them and I'm never going to have a problem, you're very wrong. Very wrong. So example number, I don't know how many of, don't try to ignore this. At least.
Yep. Don't do this at home, kids.
Yeah. I mean, if you've got to deal with it, whether you like it or not. And none of us want to deal with it. Trust me. Nobody does.
No. But doing this, trying to cover it up, just adds so much more to the problem. Now, these folks got, if you want to call it lucky, they got somewhat lucky because apparently their financial status isn't great.
I don't know if that's lucky, but yeah. Because it says, OCR even says that they took into account the financial condition of the company and negotiated a $10,000 settlement payment. It is not a fine. It's a $10,000 settlement payment in exchange for a 3-year corrective action plan. Yeah, that's going to be brutal. But let's hit what the director's official statement in the press release was. It's interesting.
So she says, when a breach occurs, business associates, can I underline that? Business associates must notify affected covered entities without unreasonable delay and within 60 calendar days of discovery. So let's bookmark that to say it's not 60 days. It's without unreasonable delay and within 60 days.
And what's in your BAA. Because the BAA, they can make that less, like 5 days. I'm just saying.
Yep.
All right.
Okay. Then it goes on. This timeliness is crucial for a covered entity to meet its own breach notifications obligations, such as timely notification to HHS and to individuals. As hacking becomes more ubiquitous, HIPAA security rule requirements, such as the need to have an accurate and thorough HIPAA risk assessment, are imperative for strengthening cybersecurity before a breach occurs.
So you got before and after. They didn't do so well. So they found they violated, what was the phrase they used? They said, I don't remember exactly what, but it was like they violated several things, is what we found in our investigation. Now, the settlement usually picks out, some big ones, the biggers. But usually the investigation, it might show up 50, 20 things. Who knows? But there are, the big ones are listed there, and that's the recurring theme of the risk analysis. It is years and years ago. I just had this, what I'm thinking about is before there was Help Me with HIPAA, I ran a blog where I was posting. I tried to do weekly. Small provider HIPAA is what I started with. And one of the articles I wrote was I used Henry VIII I Am, that song.
Second verse, same as the first.
And that's essentially what the risk analysis thing was going through then. So we're talking, well, if we started this in 2015 and I wrote it before then, so I'm just saying.
Mm-hmm.
But it was actually Henry VIII I Am, second verse, same as first. It's the exact same thing was going on then with risk analysis, which is why we have the initiative here. Anyway, I'm just, it's like saying, oh, we don't need to worry about that. We don't need no stinking backup. Programmer's last words. But, we don't worry about fire hazards and we're shocked the building burns down.
Yeah. Or, the landlord had that covered. IT covered it.
Yeah.
Or whatever.
They took care of it. Somebody else handled it.
Still hearing that one, even in 2026. Somebody's like, don't you handle all the HIPAA stuff for us? And I'm like, no. Who told you that?
No, I like the quote you gave me when you were talking about it, though. You're like, we do part of it. And you were like, go. You don't remember now.
I said, we come to the party, but we don't throw the party.
You go to Cardin to throw the party. That's right.
Yeah. I'll bring some appetizers or whatever, but no, I'm not responsible for the party.
Yeah. Cardin has to set it all up and tell everybody what to bring. So that is true, though. We still hear it. But it's clear there were so many things. I mean, it was clearly they did not have HIPAA covered. They weren't it to have, come on. 15 million breached. If either you didn't know or you didn't tell anybody, either way, not good. I almost think it would be better that they didn't tell anybody than they actually didn't know. I'm hoping it's that they knew and didn't tell anybody, because it's even worse if they didn't know.
Yeah.
I think I'm going to say it's better to hide it.
So this also points out something we talk about a lot, which is not assuming that your business associate has their HIPAA stuff together. Not saying, well, they do business with 14 million other people, so
I'm sure.
Surely they're doing everything right.
I mean, they have 15 million records, David. Surely.
I know. It drives me nuts when I hear that. Like, every so often it'll be like, well, this vendor, IT company or otherwise, they have all these other healthcare clients. So surely they're doing everything they should be doing. I mean, maybe they are, but the assumption that they are is stupid. Yes, I said that. It is. Like, don't assume that they are. Because probably what happened is they've got 100 healthcare clients, and all 100 figured somebody else did the vetting on them. Nobody did.
With 15 million in dental, who knows? I mean, they had to have a lot of clients, and now they're having to go and notify those clients on the back end, and then those people are having to now send a letter out to their patients, or at least their patients are getting notified. Oh, by the by, this happened years ago and nobody told you. So they're going to deal with the patient, the reputation damage happens to them, unless they're fortunate enough to be able to get the vendor to. I have gotten these ones where the vendor sends out a letter, you were in our breach, but I don't know which physician. They don't tell me.
Yep.
Hate those. Anyhow, we should go back and see if it says you gotta know. I have to tell you who. All right, David, what is it that we saw that was so interesting about the corrective action plan other than the 3 years part?
The fact that the privacy rule applies to business associates, not just the security rule. For those people who are like, privacy rule doesn't apply to me. I'm a business associate.
Most business associates will try to, they'll at some point you'll hear somebody say, well, we only have to do the security rule. No. I mean, this makes it clear.
Yep. It says, develop, maintain, and revise as necessary written policies and procedures in accordance with the privacy and security rules.
Also, ensure your workforce is trained with respect to
the privacy and security rule, policies and procedures.
And conduct a breach risk assessment of the cyber attack and provide effective covered entities with an accurate notice of the incident. Okay, what rule? We're all going to go on the edge with whether or not David can pass. What rule defines the breach risk assessment, David?
The breach notification rule.
Boom. See, I'm smarter than the average bear.
I so smart. Yeah, the funny part is, they're probably thinking, you mean I still have to notify people? Like, can't we just say the fact that this is making the news notification enough?
Well, but the big thing is, and not that I think you should do this. In fact, I advocate for language in the business associate agreement that says, if you perform a breach risk assessment, you will let me know. Under the notification rule, if you do it, you will let me know. Whether you agree that it needs to be notified or not, irrelevant. I want to know that you did it.
Right.
Because without that, they can do the assessment and decide, for whatever reason, if they've got and done all the work, they do the assessment and they decide that it doesn't warrant notification. Well, the only violation they've done is wrong decision.
Yeah.
I mean, could make that, it'd be really hard to get you in this much trouble. If you've done the risk analysis, if you have the policies and procedures, if you are doing all of those things and none of your BAAs say that you have to provide that information, technically, you could just say, well, I disagree. But the number of people that are in that position, apparently quite small.
Yeah. I think they have bigger things to worry about.
Yeah. I mean, well, most people are going to be in a position where either they can supply the paperwork when something happens. I mean, if you can show within reason that you're trying to do the work, that's all they want to know. But they were really worried about the financial stability of this company for them to have made so many problems for themselves, and they're only paying $10,000 in a 3-year corrective action plan. So,
Yeah.
you're right. They're lucky. Maybe.
Yeah.
But the class action lawsuits and their clients ditching them for putting them in this position and some other things.
Yeah. Well, here's the thing is there, this is where you hear people say, well, we have insurance to cover that. But the insurance provider is going to say, when was your last risk analysis? When, let's look at your risk management plan. I mean, you see what I'm saying? Like, having insurance doesn't give you the ability to skip all the other things that have to be done.
Yeah.
So, yeah, I don't know.
And you're going to get, it's the same thing. If you say you're doing those things and you aren't, then you're doing a cover up there.
Mm-hmm.
So,
yeah. So, key takeaways here: your vendors can create your breach liability. Supply chain risk. I've been dealing with supply chains attacks all day today.
Yeah.
And unfortunately, no matter how hard you try and do the right thing, your vendors and business associates can still put you in a breach. And you know what? If they don't tell you about the breach, you still own the regulatory fallout. That's not great.
Mm-hmm. I don't know. Yeah.
What about your risk analysis is not optional paperwork? What about this? How about ask your vendors, when was the last time you did a risk analysis? Can you provide me a copy of your risk analysis or something thereabouts? Like, I don't expect people to give me a copy that shows these are the risks and vulnerabilities we currently have, but show me the documentation that you performed it and what methodology you used to do that. Like, I don't want to list your vulnerabilities and risk. You shouldn't be giving that to anybody.
Yes, nobody.
So, yeah. So for those people that are out there asking for, do a vulnerability assessment or a risk assessment and then email me the results, like, that's probably a bad idea. But anyway, show me some way I can confirm that you're actually doing a proper risk analysis.
Well, and the other thing is, just like you just said, is who does your risk analysis?
Yeah, that's a good question.
That's going to tell you a lot. We do it.
Because when you say David does it, your IT company does it, I'm going to be like, no.
Yeah. Yeah.
And even if they do, let's just say that for some reason they do, because of what goes into a proper and thorough risk analysis, I would say that there's a conflict of interest there.
Yes.
Like, you really need to have a third party independent company looking at that. I don't want to assess my own stuff. Yeah. To me, whether you find anything or not that's not relevant. It's that you should have a third party independently look at this.
Well, and I've had more than one offer from, technology companies saying, merge with us and, we can do it. And I'm like, my job is to judge you. If I'm part of your organization, how am I going to say that I judge you? So are you buying? Because what I do is that. So what are you wanting me to merge to become? Because we will have to change what our core product is in order to do that.
Here's another one I'll throw out there. If your IT company or other vendor tells you, we can bring in XYZ compliance group and they will do all this assessment for you. And my next question would be, are you getting a kickback on this?
Mm-hmm. Yep.
How do you fit into this cogwheel? Because there are companies out there that will, they'll say, look, you can resell our services into your client base. But I think that is another conflict of interest. if Carden is giving me a kickback and I'm bringing Carden in and I'm like, I want you to assess how I'm doing. And oh, by the way, you know, on the back end, you're going to pay me for this or whatever. Like it's a conflict of interest.
No, yeah, no money. That's my big thing is I always get that question. Well, if I give you all of my clients, then, you know, you're going to pay me to do that. And I'm like, I can't pay you to do that. You know, and organizations are like, oh, but we've got all these people. And if you pay us, then you get access to them. And I'm like, do you know how hard it is for me to get people to agree to pay if they don't even know who we are? So just having my name connected with an organization doesn't make a difference. It's actually understanding what it is you're supposed to be doing. And until you do, you don't understand the value of it not being just your IT company.
Yep.
Anyway, that's all I have to say about that.
I started seeing your blood pressure go up.
It's been one of those days, hasn't it?
All right. Anything else before we put a cap on this one?
Yeah.
You know, 3-year cap maybe.
Bump. One other important thing is to remember you can't assume that OCR is not going to find out about something. If you know you're violating the rules, you know, and I've had people say, well, we're just going to keep doing what we're doing and hope that, you know, they'll give us a break on it when something goes wrong. I'm like, that's not really the objective. It's not about the regulation. You know, the regulation is to try to get you to see this is what you should be doing. So
yeah. It's just like, do the right thing.
Yeah.
Why does somebody else have to tell you that you need to do the right thing to protect the people that are now victims to, you know, this data breach? To me, it's mind blowing. Well, because it says a lot about the integrity of leadership that you would do that.
You know, and it's like these guys, it'll destroy our business. Well, guess what? You're not in a better place, it doesn't sound like. So, also, and we've said before, they read the news. So,
yeah.
You know, they might see something in the news. So, keep in mind that these things are not something where you're like, well, just don't tell anybody. Because somebody knows, like the hackers or the people that bought the data, or, you know, people know you can't keep these kinds of secrets forever. And the longer it takes for the secret to come out, probably worse it is, unless you're already, you know, retired somewhere on a beach. But who am I?
And even then.
Could end that retirement plan right away, depending on the plan.
That's right. All right, folks, that's our show for today. Thanks for listening. Be sure to join us again next week. And remember, for Donna and myself, the HIPAA is not about compliance. It's about patient care.
That is right.
You've been listening to the Help Me with HIPAA podcast, hosted by Donna Grindle and David Sims. The show created to help you with HIPAA. For more information or to ask us a question, visit our website at helpmewithhipaa.com. Neither Donna Grindle or David Sims are attorneys, and they do not offer binding legal advice concerning regulatory compliance. The information in this podcast should not be relied upon or construed as legal advice in any way. Consult your attorney for legal advice concerning compliance with HIPAA regulations.